lordships have used the expression appellate, and said that look, there is no appellate review when even in a 34 situation when we are examining the correctness of an award. So my broad endeavor will be to try and satisfy you that the view which has been taken on each of the points which my learned friend has raised qua arbitration is a reasonable and a possible view. My primary stand, of course, is it is the correct view. But I need not, in my respectful submission, satisfy your lordships on that entirely. If you feel that it's a reasonable and plausible view that has been taken, then my request to the court will be, please sustain it. And that appears to be the manner in which the case has proceeded here. Now, broadly, 4 grounds, as we understood it, was raised by my learned friend as far as arbitration. Now I'm on arbitration. So the first ground was that, look, there are 2 clauses in the arbitration clause. There is clause 1 in the agreement of 1985. There's clause 1 and there's clause 19. And the first submission made was that clause 19 overrides clause 1. So that was the first point. The second point which my learned friend made was that, look, in any case, clause 19, which enables them to, that the law generally applies as far as port trust, etc. is concerned, this takes them to section 52. And as far as section 52 is concerned and the power to fix rates are concerned, that is a statutory power which they are entitled to exercise, and therefore they have so exercised the power, and therefore that must override whatever agreed rate might be there insofar as clause 1. That was the second argument. Statutory power traceable to 52. The third argument was limitation. The fourth argument was, as we understood it, section 55 of the Major Ports Act, which prescribes that if there are overpayments and overcharges which are made, then how are those to be recovered, etc.
6 months limitation.
Yes, there is a narrower period of limitation. 6 months you have to go through that process, and the argument on the submission was that unless you go through that process, you cannot sustain a demand. Now we will endeavor to satisfy your lordships that on each of these points, a plausible view has been taken.
You can ignore section 55.
All right, very well. Then I'll focus on the other aspects. Now, my lords, now one thing, and I think unless I missed it, but I think I was here for most of the hearing, meaning I might have stepped out briefly. But your lordships haven't yet really had a chance to look at the award itself. I mean, of course, submissions have been exhaustively addressed on every dimension. So I'll be spending a little time on that. But first, may I take you straight away to the agreement and and make my short submissions of the agreement, so we are now, my lords, on page 51 of SLP 9751 of 2023. So now, my lords, I'm on that agreement, except one document. In fact, the very next document I like is in the other SLP. But I will just request you to now go directly to this particular agreement, the subject agreement. Your lordships have it?
Yes.
Yes.
975. Yes.
Yeah. So page 51 is the agreement of 3rd August 1985.
Yes.
Justice Sundaresh has it?
Yes.
Yes. So I'll just make my short comments on it. Now you'll see, of course, the Board of Trustees, etc., Paradeep Phosphates, which are the parties. Then please see the last recital. Whereas Paradeep Port Trust agreed for construction of such a berth in Paradeep Port, hereinafter called the fertilizer berth, and proposed to provide berthing facilities exclusively for Paradeep Phosphates Limited on the following amongst other terms and conditions. Now, this is a very, very important request. So I'm just pausing here for a moment. I have a huge facility and a plant. I require a berth for landing goods and cargoes. This is not an ordinary situation because, of course, at that time, as the court correctly and as my learned friend also correctly said, this was a public sector undertaking as well. But at this time in 1985, there was a huge requirement for an exclusive berth. Because parties are, you see, they are entering into a contract. There are on both sides commercial terms which are involved. There is a public interest from the perspective of both, and there's a private interest involved. So to today wish away and say that I am going to terminate, I don't like you, I want to close down this exclusive berth is an inroad which I don't believe this court would allow, because this is a permanent facility on which I am crucially and vitally dependent. Of course, if I commit some violations under the agreement, it's another matter. Then, as per the terms, etc. of the clause, those can be acted upon. But so long as I'm compliant, this is, as the recital seems to indicate, an exclusive berthing facility for Paradeep phosphates, but it's on various terms and conditions. Now, I'll be emphasizing 5 or 6. Now, please see number 1. The said captive berth. So that clearly gives you an indication that this is for me and for me alone. Shall be exclusively provided for use of the Paradeep Phosphates Limited, subject to payment of the rates mentioned in the schedule of rates annexed to the agreement, and will become payable 1 calendar month after the berthing of the first vessel at this berth. The rates now charged can be suitably enhanced at such intervals as would be mutually agreed upon by the parties from time to time. So I emphasize the expression mutual agreement for enhancement at periodic intervals and agreed upon by the parties from time to time. There's also, so this is one thing. Now number 2, so the main point here is the bargain between the parties is that there are rates which we have negotiated, which we have agreed upon, which are part of the contract, and if there is a departure to be made, it has to be by mutual agreement. That's the broad sense that I have. Now, please see the location and position of this clause. It is the very first clause, and I believe this is very important because as far as the first argument is concerned, which is to say that this clause gets completely wiped out by clause 19, doesn't in our respectful submission appear to be a sustainable submission at all. And certainly, of course, as I said, that there is a possible view that this is the core of the bargain between the parties. One
issue will arise.
Yes.
This says by mutual agreement.
Yes.
Suppose there is no agreement.
Yes.
So that would mean that these rates will continue for all.
No. So there is always. So let me just straight away tell your lordships. There are 2 parts to my answer. The first answer is that if a dispute arises because somebody is not acting reasonably with regard to a term, then you can always resolve the dispute in under a machinery which is available to you. So that's my first answer. So you're absolutely correct. This engenders and requires reasonableness, and I might just tell your lordship that has also been looked at by the arbitrator to examine whether their demand for enhancement was at all reasonable, unreasonable, etc. So he looked into all of that and found that no, there was no justification on that. So that's an important facet and obliged to the question. So my short answer is there is a machinery without anything further that if a dispute arises between the parties, it can be resolved by going to a neutral forum. One. Now we have a second answer to it. The second answer is that
Will be that neutral forum?
it could be an arbitrator or it could be a civil suit. If somebody is acting unreasonably under any agreement, it can always be a civil suit. Otherwise, I'm sorry.
They can't be.
Sorry.
Just a minute, let him argue. You can reply later.
Yeah.
Otherwise, we will not understand.
Yes. Yeah.
Then why can't it be as per the act only, the procedure?
Yes, so let me, because the parties, I'll just answer that question in a moment, but let me provide the answer right away. There is the schedule which we saw and which is referred to, but which we haven't yet seen, makes a distinction. And the schedule itself refers to the scale of rates. So what you will find is that where the bargain between the parties was that the scale of rates which they fix will apply to certain items. So that there will be flexibility as it goes up and down, but certain other items are fixed. But to answer the earlier question of the court, which was, is this, if somebody withholds, what is to happen? Now, moving forward, there is no problem at all. Why is there no problem at all? Because both the sides have accepted the position that TAMP will determine these particular rates. So moving forward,
That is after 99.
yes, you're right. So because there may have been some argument earlier whether it is TAMP, not TAMP. TAMP itself has said, look, if there's an agreement, why have we come here? But there was an award. The award said that from 1st April 99, it is TAMP. From 1st April 99, both the parties have accepted it. They have put proposals from time to time before TAMP. TAMP has examined it, and they will therefore fix the rate. So now we have an external regulatory authority. So this problem, which may theoretically have been there at some point of time, no longer exists insofar as withholding is concerned.
Future, there is no problem.
Yes, but remember and recall, in my respectful submission, a very, very important facet. When parties such as these are entering into negotiations and fixing a schedule, they have anticipated that this is going to be an exclusive berth in perpetuity. And they factored those elements in terms of costs, in terms of requirements and all of that. So when you have a bargain between the parties, and they have consciously agreed to this particular bargain, it cannot be unilaterally departed from, whatever the other situation might be. Now, my lords, I want to just take you straight away to that schedule, then I'll come back to the agreement, because the schedule is part of the agreement. Now, the schedule, you will find, and this is what I just mentioned, this is in my counter affidavit in this particular SLP, and it's at page 102. So it got left out when they filed the main petition, but it's part of the thing. So if you take my counter affidavit, page 102,
So that.
your lordships have it? Counter affidavit.
Yes, you can start.
Does it titled annexure?
Yes, it is.
Correct?
Yes.
Right. Now this is the annexure to the agreement, correct, with the schedule of rate. Now just see how it is subdivided. One, a fixed charge of rupees 30 lakhs per month, irrespective of the quantum of cargo handled, plus a consolidated unit charge, which will vary with the throughput as indicated below. Now please see how carefully this is done. So 30 lakhs is irrespective of the quantum of cargo. Vessel comes, doesn't come, 30 lakhs has to be paid. Then there is a varied sliding scale. So it says up to 3 lakhs per metric ton, the amount is given more than 3 lakhs, then A and B more than 6 lakhs, more than 9 lakhs, more than 12 lakhs per year. Your lordship has that?
Yes.
So there is a sliding scale that as per metric ton, depending upon the tonnage which moves through that particular port. So very carefully drafted and all. Now please go to Roman 2, which is very, very important for my purposes. Very important. Roman 2, page 103. Again, part of the annexure. In addition to these charges, it should be Paradip Phosphates Limited will pay other charges, namely tug hire, pilotage and port dues only as per the scale of rates. Have you got that? And no other charges like berth hiring, warping, mooring and immuring charges. Now, so notice two things. The parties consciously are aware of scale of rates. For scale of rates to apply, they specify where it will apply. For tug hire, pilotage and port dues, it will be per scale of rates. That's the contractual bargain. So that is where you go to scale of rates. You cannot go to scale of rates for everything and everything, including this 30 lakhs, etc., which is specified. So this is one very, very important plank on understanding one. One can't be understood without the annexure. The annexure's breakup draws our attention to scale of rates and draws our attention to non-scale of rates prescriptions. So this ought to be read together. And just before I go to the other clauses, just have a look at clause 20 of the agreement itself. This is again to answer Justice Bindal's question. Clause 20 of the agreement, which you will find at page 56. Because we are reading the clause as a whole, the agreement as a whole. I'll come back to the other clauses. But look at 20. That in case of any dispute arising out of or in relation to the clauses of this agreement for interpretation of terms of the agreement, the matter may be referred to arbitration. Your Lordship has that? So, if there's a dispute, as the court put to me, what is the machinery? So, there is a whole detailed scale of rates. It's clear, it's categoric, no confusion, clear division, and there's a dispute resolution machinery if somebody withholds consent mutually or, unreasonably. Now, please go back to those clauses.
That process was followed ultimately.
Yes, but with a variation. You're quite right. With a variation. Now please go to clause 2, page 52. So mutual agreement I have, your lordships have noted. Now clause 2. That it shall be the full and absolute responsibility of Paradip Phosphates Limited to make such constructions and install such equipments exclusively at their cost in the berth to ensure smooth and safe loading, unloading, handling, pumping, storing, transporting of any cargo, either solid, liquid or gaseous, brought to and the said captive berth by Paradeep Phosphates Limited directly or its agents, successors, assignees, and that it shall have absolute responsibility of Paradeep Phosphates to maintain, repair, replace such installation, equipment and machineries from time to time and or in the event of any damage or loss. That such installations and fixtures stated above, even if done permanently on the ground within the port limits and its vicinity, would not vest or create any right, title or interest in the land in which such permanent installations are made in favor of Paradeep Phosphates Limited, their agents, successors and assignees, and the same always continue to vest in the Paradeep Port Trust. That the Paradeep Port Trust shall be completely responsible to manage the facilities built by them by unloading and loading of ships and for storage, handling, transportation in the fertilizer berth in any manner mechanically or manually, and the Paradeep Port Trust shall not be responsible in any manner, and the Paradeep Port Trust shall not be in any manner responsible to carry out the above work. Only personnel of the Paradeep Phosphates Limited or its authorized representative shall be used. That 5. Paradeep Port Trust Phosphates, shall be responsible to build and operate a control room. 6. Paradeep Phosphates shall have the right to bring any cargo, either liquid, solid, gaseous, both bulk or packed condition, to the fertilizer berth or ship in either liquid, solid or gaseous form from the fertilizer berth, subject to normal regulation regarding safety, draft limitation, etc., governing shipping of the port. Then I'll skip the next few paragraphs. Please see numbered clause 10. Paradeep Phosphates Limited, that's myself, shall have the right to determine the priority of the berthing of the ships calling on their berth or intending to use their berth, including the right to shift the vessel already working on the berth and bring in another vessel to the berth for unloading, loading, subject to the traffic regulations of the Paradeep Port Trust and consistent navigational facility. And then I'll take your lordships directly to clause 19, which is relied upon by the other side. That the Paradeep Phosphates shall be subjected to the application of all relevant laws, rules and regulations of the Paradeep Port Trust that are for the time being in force and that would be framed and enforced from time to time. Now just look at the broad frame. I will of course see what the arbitrator has said, but broadly I'm making 3 points. Yes. So I'm just making 3 points. When you have a specific clause giving the rates, which is the heart of the contract, apart from exclusivity, I don't believe a general clause like 19 can be used to completely negate and wash it aside. But I don't want to use strong language, but I think it's certainly a possible interpretation that clause 1 doesn't get drowned out by clause 19. It doesn't get drowned out, because that was their first argument. The 19 trumps clause 1. There is nothing left in clause 1 if we decide to exercise our statutory duty. That's one. The second point I would reasonably request the court to consider is, when the parties consciously within the annexure of the scale of rates make a division between scale of rates applicability and fixed charges which they specify in the agreement, then as far as 19 is concerned and the powers of 19 are concerned, that cannot be used again to override what is specified in terms of clause 1 with the annexure. That's the second limb of the submission. The third limb of the submission is, which appeals to the court, and there are, apart from our court, which is the High Court, there's also another Calcutta High Court judgment which I'll point out, that the clause 52 not use, I'm just flagging it, we'll go to it, does not use or open with obstant clause, notwithstanding anything in any contract. And 2 High Courts have taken a possible view that, look, absent that, you can't just say that there's clause 19, there's a power to fix scale of rates, and therefore anything and everything which a party bargains to can be overridden unilaterally. And the final point, I'm sorry.
Section 52 you are referring?
Yes, 50, because that's their argument. Their argument is that they have a power to fix under 52. So read 19 with section 52.
Whether the section in an act is required to mention that notwithstanding anything in agreement also?
Yeah, so the High Courts have looked at various examples and given examples and said that many times you have, because there's a sanctity of contracts. I'm obliged to the question. There's a sanctity of contracts. Sanctity of contracts is a very important principle, and I'm how parties make bargain, force bargains, and arrange their affairs. So here you have an affair which is arranged in the greatest detail. But to answer your lordship's question, there are sometimes, I'm not saying it is determinative, but there are sometimes you will recall in your vast experience, clauses, statutory provisions which say, notwithstanding anything in any contract, judgment, deed, etc., this particular statutory provision will prevail. It's absent here, but it's my next point is a very important point on construction. Broadly, yes, I'm sorry.
It's all not required. It is not even their case.
That
It is not even their case. See, their case is simple. Their simple case is clause 19 with 52. Your case is clause 1. Clause 1, according to you, it is a charging section and it is its impacting section. Therefore, clause 19 cannot be read into clause 1 is your case.
Yeah.
Their case is also clause 19 will not come with the clause 1. What they are saying is, put it that way, clause 1 will come first. Then, even let us assume that both of you agree for the revision of rates. Even then, one has to comply section 49 read with 52. That is what they are arguing. It's so good. That's not, let's see.
no, so I just
As we understand the argument, it becomes easier.
Yeah, so I'll just respond to that argument. But if that is their submission, it is not as if once you have the scale of rates is one area in which they have power to determine the rates. It doesn't prevent them from entering into contracts. They have a power to enter into contracts. So when they enter into contract for a special situation, which is the creation of an exclusive berth only for a particular party, you can always have the power of contract is not limited. It is not in any manner circumscribed. So you have the full power. That's what the parties did. That's what the parties did, and eventually that's what the arbitrator has said. So, to answer your lordship's question, when you have clause 1 and you also have clause 19 and you also have section 52, the correct way of reading it, which is what the arbitrator has done, is that you have to read them together. And if you read them together, what it essentially means is that you cannot use 52 to unilaterally change something which has been agreed to in clause 1. You have to read it in harmony. And if you read it in harmony, clause 1 is paramount, mutual agreement. If you can't arrive at a mutual agreement, it doesn't say that you have a veto by virtue of section 52. No. Your scale of rates is also mentioned in the annexure as to when you can make a change. And those are the only items on which you can make a change. So that's the broad way of reading it. Otherwise, what is the purpose of clause 1 at all? There's no purpose at all. So therefore, sorry.
Yes, sir, purpose. See, when there is a contract between the parties, one is not expected to look at as if they're each clause is mutually destructive against each other, not in conflict.
I agree. I fully adopt that. Fully adopt. Yeah.
Clause 1 says mutually agree.
Yeah.
Whether you
One increase.
agree, that's what increase, only increase.
Yeah.
So therefore you are right.
Yeah. But no, sorry, one thing I should tell you. Make a submission. Parties who enter into a contract always renegotiate a contract. So, you're right, increase. And let me just also, in anticipation of, tell you that in certain respects, adjustments have been made up and down. But please continue.
That's a little bit.
Yeah, let's parties agree to that.
They can do, no?
Of course.
When the clause 1 says, you can negotiate. If supposing negotiate, no problem.
Yeah.
What they are saying is, even then, you have to go under clause 19, which means clause 19 is complied with certain way, meaning thereby section 49 read with 52 will have to follow.
No, that's not his case.
That is his case.
No. It's not as if the 85 rates have been notified. The 85 rates came in from the very next month. As prescribed. Please go back to clause 1. Clause 1 doesn't depend upon a statutory notification to take effect. Please just see that. That the captive berth shall be exclusively provided for Paradip, subject to payment at the rate mentioned in the schedule of rates annexed to this agreement, and will become payable 1 month after the berthing of the first vessel at the berth.
In their scheme of rates, separate charges.
I agree. That's what I accept. Just
given that this process of it's followed. We will not be talking about
But let's talk about his how the legal rules to work.
yes, sir.
Okay. So we will say that it has to be consistent. Putting it into the so Manoj, my respectful submission is just to on this particular point. When you receive the charge, you must follow it. One. That takes into effect directly between the parties. It doesn't require anything further to be done as between the parties. I can't say that, oh, you didn't notify it and therefore nothing is going to happen. I'm not going to pay until then. The moment the clause says that after your first vessel, whatever, 1 month, etc., you have to start paying. Now, what they did was, and what they do is, that this agreement between the parties, because there are many such situations, you will recall, they mentioned Oswal, your Lordship recall, they had a separate subsequent facility with Oswal and IFCO, you remember that?
Yes.
So what they do is, and which is the correct thing, once there's a negotiation between the parties and there's an agreed rate, they may notify it in their statutory scale of rates under a separate item. So not under the general item, because that was another argument made that, oh, please apply me under the general rate. No, their writ petition, their grounds, all of them are, please apply the IFCO rates to us as well. I'll deal with that separately when I deal with tariff. The point being made, therefore, is that once you have a negotiated contract under your powers to negotiate, you have a bargain, then it becomes your duty and obligation to notify those very rates when you issue the scale of rates, which are mutually agreed. If you want a variation and somebody, the counterparty is unreasonably withholding consent, then you cannot do anything unilaterally, is my respectful submission, which has been accepted by the courts below. You can certainly raise a dispute, go through an arbitration mechanism or whatever manner which may be available to you. But you cannot say that I have clause 1, wink, wink, I have got a statutory power under clause 19 and therefore this one I'll just tear up if you don't agree to whatever rates which I prescribe. That's not the way anybody reads a contract. I mean, that's my, and in any case, it's a possible view which the arbitrator has said. Now, this is, I have completed, my lords, the clauses in the agreement. I have placed before you clause 19 as well. And my respectful submission, just have a look, subject to the application of relevant laws, rules and regulations of Paradip that are for the time being enforced and would be framed and enforced from time to time, is a general provision. It just means that people can't act contrary to the law. But equally, when you have a bargain, the obligation of a party is to uphold the contractual bargain and the contractual rates between the parties. So now, my lords, your lordships have seen this. Now I go to the second part of my submission. You have seen the agreement and the annexure. Now, I want to, in the next set of submissions, I want to take you to a series of documents, and which are illustrative, and I'll just tell you what these are about. At least I understood a suggestion made by the other side that from 1993 onwards till 2000, there wasn't a whisper of protest or something like that, and therefore they pleaded acquiescence. Now, what I am going to show to your lordships, so just keep 2-3 things in mind because these are important. You have 2 public sector companies. Please keep that in mind, number 1. There are negotiations, what you will find from the correspondence, requests which are being made by us, requests being made by my parent ministry, and you have even a response which I will take your lordship to, all of which was considered in the... But that hasn't been shown to you, so I'm going to show that to you. And therefore, there was obviously, it's a reasonable interpretation which the arbitrator has reached, saying that, look, these were live issues. There were issues which were made under protest, payments which were made under protest. And eventually what happened in June 2000 when I went to court was, it snapped up. They said, finally, because all this is going on, talks, meetings, etc. And it snaps because they issue an ultimatum saying that I'm not going to allow your vessel to come. Now, when they said that you're not going to allow your vessel to come and land, I had to go to court and get a protective order. And that in turn led to, so until then, there was no such threat of, we were imploring them, we were requesting them, we were pointing out this mutual agreement request, etc. And we said that, look, let's, whatever, sit down, negotiate, discuss, etc., which is what the law requires. Now, when that didn't happen, they also, so now let me take that correspondence and just with a preface, that this is what was placed, this was what the arbitrator also considered, but I'll deal with the award at a go. So, my lord, first, please go to my counter affidavit, because we have appended some of these documents there, some of those which were filed in the tribunal for our purposes, 5 or 6 letters. Please go to page 104 of the counter affidavit, R4. This is to meet the point that there was not a whisper of protest, and all of a sudden, after so many years, this comes up. So 16/3/93, Your Lordship has page 104. So now this is my letter. It's addressed to the chairman, SLP petitioner's chairman of Paradip Port Trust. And it talks, the caption is proposed revision of consolidated unit charge. Paradip Port Trust, so-and-so agenda is proposing a revision. The proposed increase would entail an additional expenditure of 183.83 lakhs on our part. Apart from an increase in vessel-related charges, a calculation statement is attached herewith for your kind perusal. The consolidated charges payable by PPL are as per the agreement entered into between PPL and PPT on 3rd August 1985, which provides in para 1 at page 2, and then it sets it out. My lords, your lordship recalls that mutually agreed upon.
When the revised dates were notified?
93, I'll just give you the date.
Which date?
8th October. 8th October 93.
Letter is prior to that?
This is prior to that. Well, the next document I'll show you is the tariff notification. Yes, it is prior to that.
So at that stage there was nothing.
It's a proposal. If your lordship just sees that, now, may I just come back to the top of my letter? Paradip Port Trust Vijay agenda item is proposing revision of. Your lordship has that? Proposing revision of consolidated unit charges, etc. And then we say that, look, this is what it is going to have an impact on. Please see top 2 lines on page 105. You will kindly appreciate that the unilateral increase in the rates is contrary to the terms of the aforesaid agreement. So we put forward our point of view. As you are kindly aware, that is a sequel to the change policy regarding pricing and distribution, so-and-so fertilizers, full convertibility, etc. We are unable to meet even our day-to-day urgent financial commitments. Therefore, we say that, look, 183.83 lakhs shall be too difficult a burden to bear. We would therefore request you to kindly review the proposal and increase the consolidated charges payable by PPL and a proposal of increase in consolidated charges payable by PPL till such time as our financial condition improves. And we are mutually able to decide charges which are payable to you. So this is how party, of course, this, as you have correctly put to me, hasn't yet come into force. So this is how parties respond to public sector undertaking. Now please go to the, since the court correctly put to me, the tariff notification, and you will find that in the SLP itself at page 58.
May I give your lordship the date on which the central government approved? It is Millard 20th.
This letter is at the stage of proposal.
That's right.
Yes.
21st
But
of
it is after the rates were notified.
yes, 21st of September 1993
Yes.
is the date of approval of the central government.
Yes.
So Millard, October is when Millard it was brought to them.
Yes, so I take you straight away to the October date, and please go directly, Manoj, now to the SLP paper book at page 58. This is my next date, 8th October 93. This is the tariff notification. It says 5th October, Manoj, but the Gazette itself on top you will find is 8th October. Do your lordships have that?
Yes.
Right? So these, I think the pleadings, etc. have both dates. But anyway, go by 8th October. Now, once we are on this tariff notification, please go directly, part of the same notification, go to 76. So this is just for your noting. Charges for cargo of Paradip Phosphates Limited handle. Your lordship has that as a fertilizer board. So this is shown as a separate item also. And at this point, just so that this is behind us, I request you to just go to, in the same SLP paper book, to go to page 113. 113. Now, why am I taking you to 113? I'm taking you to 113. This is part of the award. Here, the arbitrator has looked at the impact. So, I'm placing it before you in a tabulated form. Do you have a table there?
This is the award of the
This is part of the award, but I'm just taking you to that one paragraph so that you have the comparison. So, in the revised scale of rates 93, cargo-related charges pertain to Paradip Phosphates Limited were revised as under. Your lordship has that sentence? About fifth line on 113. So the various rates are given left-hand column, right-hand column, and then see the next consideration by the arbitrator. After the table, the percentage increase in the unit rates between 85 and 93 has been ascertained to be as under. And so he has just set out that percentage increase. 19.5%, 34.62%, 38.89%, etc., etc.
One part there is decrease also.
Yes, so you're quite so. So we'll go by this, Manoj. I mean, I don't think anybody has questioned the arbitrator. I thought I'll take you to this so that you have an idea. There was an increase, there was an application of mind by the arbitrator. Now please go back to that correspondence chain, which takes me back to my counter affidavit at page 109. Now this is again a letter which I have written on 8th January 94. 8th January 94. It's addressed to the chairman of Paradeep Port Trust. Your Lordship has that. Heading on page 109 is Paradeep Phosphates Limited, Government of India undertaking. Then it's to the chairman, etc. This has reference to our letter of so-and-so to the chairman, 2nd December 93 from the accounts manager to the traffic manager PPT on the above mentioned subject. It is brought to your kind notice that PPT authority has started enforcing the revised rates on PPL cargo handled at PPL jetty. It is mentioned in our above two letters that with respect to the terms of the agreement entered into between PPL and PPT on 3rd August 1985, para 1, page 2, the agreement provides as follows. And this is the same clause saying mutually agreed. Any enhancement of rates to be mutually agreed upon between PPL and PPT authorities, but the present revised rates have not been discussed and agreed upon by PPL, and this is a one-sided revision, etc. Therefore, we request, please see the last line, it is once again requested that the revised rates of cargo may be reconsidered by PPL and may allow to make payments at the old rates till such time as a mutually agreed rate is arrived at. Now, this is exactly how a public sector undertaking responds rights to another, or even two corporations' rights to another. Now you will find a further letter, please see 112, 9th August 1994. 9th August 94. Now see this correspondence, 113, page 112, it starts at 113. We thank you for the courtesy extended to us during our discussion we had on 9th August. During the discussion, we had explained that the revision of rates by PPT with effect from October 93 is not in line with the agreement between PPT and PPL. Then I'll skip that next line, and after that, we again appeal to PPT should reconsider upward revision, etc. Then please see last 5 or 6 line. We note that PPT has claimed interest on the outstanding payment, etc. amounting to 58.09 lakhs cost of replacement. Kindly consider the above adjustment. Give us credit for these dues. Further, as per the agreement with PPT, there is no provision for charging interest. Therefore, we request you to cancel the debit notes issued in this connection. We are therefore returning the debit notes, by enabling you to cancel it, etc. Now, see the next line is very important. While the subject of interest charged by PPT without prejudice to our above contentions, we also note that the rate of interest is 22.5%. Even as per paragraph 1, so and so, it should be 18.25%. Pending a decision on the above matter, we shall continue to pay the monthly fixed berth charges and some additional amounts towards earlier dues. So, we are making a request here. We are saying it is without prejudice. Expressly saying it's without prejudice. Please consider. Thank you for your time for the discussions. And this, as your Lordship saw, was on 9th of August 1994. Now the next document, please go to 116. Now this is the ministry. So this is at the ministerial level, from the Ministry of Chemicals and Fertilizers, and it is to the Ministry of Surface Transport. Your Lordship has that? Because we are under two different ministries. Now please see 4th August 1995 on page 116.
This was prior to your letter.
Sorry, 4th August 95.
Prior to your letter. The earlier letter you read.
No, 95. No.
Oh, this is 90. Yes.
I know, look, I'm giving you a sample to just show that this issue was alive, discussed at the ministerial level, other levels. We can't just rush to court And there was no hardened stand. Important thing is there was no hardened stand till they say, I'm not allowing your vessel to come. Everything is, we are trying our best. So dear Khairwal, Pradeep Phosphates, a public sector company under the administrative control of this department, entered into a long-term agreement with Paradeep Port Trust in August 85 for the exclusive use of a berth at a fixed charge of 30 lakhs per month, consolidated unit charge on a graded slab basis. Though the agreement provides for enhancement of charges by mutual agreement, PPT has unilaterally increased the rates from October 93, imposing an extra burden of 182.50 lakhs per year on PPL. PPT has also earned substantial revenue by hiring PPL's captive berth to other parties without giving PPL any relief in its rental. We have repeatedly requested the Ministry of Surface Transport to look into this matter and prevail upon PPT to give a fair deal to PPL. Copies of a one-sided correspondence in this regard are enclosed. I shall be thankful if the relief sought by PPL is expedited. Now, this is the ministry writing now. You must take it. I mean, the ministry may not be correct, but at least when he says that we repeatedly are following up with the ministry, please take some decision. That must be believed when he's sending a communication to the ministry. Now, next year, just please go to a further correspondence of 24th April 96 at page 118. 24th April 96 now. Again to the chairman, this is my letter. To the chairman. There's a typing error there in subject. It should be cargo related charges. May I request you to just correct that? Cargo related charges on imported raw material. Dear sir, this has reference with the discussion we had with you on 22nd November 95, in which it was agreed that PPL's request for reduction of cargo and related charges will be reviewed and put up to the Board of Trustees for consideration. We are placing below the following points for your reviewing and putting it to the Board of Trustees. We give it. Then see number 2. These changes have been revised by PPT unilaterally with effect from 8th October 93. And then we've given the unloaded cargo. Additional amount paid by PPL during the last 3 years due to the upward revision in the freight works out to. We've given those details. It may not be out of place to bring to your notice that the charges applicable to PPL is much higher than the charges applicable to other fertilizer companies who are having similar berthing facilities and priorities at other ports. The details are given. Now please see, there's Coromandel Fertilizer at Visakhapatnam, there is FACT at Cochin, and the tariff applicable to GFCL at Visakhapatnam. These we give. Then we say, from the above, it can be observed that the cargo-related charges levied to PPL are 1.5 to 3 times more than the charges applicable for similar cargo handled in other ports. Trying to come out of the situation by improving its production, we would be very much thankful for you considering our case and restore the rates applicable in the original agreement of agreement till March 1996. For the current financial year, new rates may be fixed after mutual negotiation and agreement. So this, Your Lordship saw, is a detailed communication, again making reference, requesting that please put this up to your board on 24th of April 96. Now please go to page, immediately to page 123, 15 July 97. This is a communication by me. Dear sir, with reference to your letter, we would like to convey our thanks for inviting us to attend the meet with the port users. Now just see how this goes, man. See how they have put it. In this connection, we would like to inform you that PPL is having certain genuine grievances which have been brought to the notice of the Port Authority several times in the past. But due consideration has not been given. We also feel that PPL's problem being unique in nature, which is related to our captive berth, it is felt that no useful discussion can be made regarding PPL in a general meeting with all other port users. Our main grievances are given here under revision of scale from 8th October 93, then charging interest on belated payments. Now please see the last 2 paras. We therefore request you to kindly fix up a separate meeting with PPL at a mutually convenient time and date for discussing our grievances as indicated below. Last line, we would like to have a discussion on the same with facts and figures so that the same can be mutually sorted out. Then please go to 13th page 129, please. 13th April 98. Again, we're on the subject of revision from 1993. We refer to the fact that there was a unilateral change.
These are various letters.
Yes. Now see the last line, last sentence in the first paragraph. Further, this point was also discussed in a joint meeting held between the chairman PPT and the managing director of PPL with a record note of discussion on 2nd November 95. We would like to request you to compare the rates charged by other major ports. It would be observed that incidence of various dues charged by PPT was abnormally high. Besides this, action by PPT authorities to revise the rates upward, contrary to the agreement, is a matter of great concern. Unfortunately, in spite of protracted correspondence with PPT authorities, our requests are not yet considered. Now see the last two paragraphs. We will appreciate if your good offices shall review the matter once again for restoring the rates as per the earlier agreement with retrospective effect from 93. It will be our pleasure if you can spare some time of your valuable time for a joint meeting where the issues can be discussed and a suitable decision taken can be taken at the earliest time. So here again, my lords, we implore them. Now please see a letter at page 136. Now this is their chairman writing. It's a very important letter and it's been considered by the arbitral tribunal, as have these other letters which I have written. Now please see, this is 17th December 1998. It is addressed to my chairman and managing director, chairman level. Kindly refer to your letter of 6th November 1998. While apologizing for the delay, let me state the facts from the port's point of view as below, which I am sure you'll appreciate. Then he talks about berth hire charges. The cost of a berth is not exactly the cost of the civil construction of the particular berth, which is the year of construction, may be around 31 crores. No one can construct a berth with that amount anywhere in the sea. Berth is a part of a harbour system, which consists of channels dug and maintained in the open sea, breakwaters, protection wall, etc., etc. All these require a huge investment, which at current cost may exceed 1,000 crores. Therefore, it would not be very logical to adjust the berth hire rent against the capital cost of civil construction of the berth alone. Secondly, the recovery of investment of say rupees 31 crores should not be assessed in a cumulative manner, but with relation to day to rate of return, IRR, and a return of 1 lakh per day on 3.6 crores. Then it comes to the agreement. The agreement between PPL and PPT was reached at a time when the policy framework for privatization and captive berth arrangement were not crystallized by the Ministry of Ports. After 1991, these policies have spelled out, according to which a captive berth can be given only on the basis of a minimum throughput guarantee worked out on the basis of a capacity of the berth. Thus, the user of the captive berth, has to pay wharfage, and for that quantity, even if the actual cargo is less than the committed quantity. For example, in the case of Oswal, now please remember, Oswal is 98. Oswal is 98, I am in 1985. Oswal Chemicals and Fertilizers, who are also taking a captive berth, it has been decided to and agreed to them that there shall be a minimum commitment of 2.5 million tons of cargo beginning from the second year of its hiring, until such time as the commitment to stop services of your incoming vessels. Now, until this point of time, the reasonable view which was this was instituted, you may just note, on 30th June 2000, correct? Now, I don't need to read to that, but basically page 93 in the opening paragraph, we refer to the captive berth. And then the clause, obviously, that it has to be by, my case, which is it has to be by mutual agreement, that there's a problem and that they are threatening to stop services, etc. And so the reliefs which we seek, you will find in the suit, are at page 97.
Can't amend.
Sorry?
You say they can't amend the terms.
We had to immediately get that relief, etc., which is what we got because we couldn't afford to have a disruption in our manufacturing, etc. Now, the next document which you may see is the arbitration agreement, which is 10th August 2001. And you will find that document in SLP 9870, if you know. Second SLP, I think that was given to the court for, was it? No, yeah, Your Lordship says, I just have to refer to the second SLP, main paper book, just to cite that agreement, Manoj, the arbitration agreement signed between the parties.
Page?
Page is 101. Your Lordship has it, 10th August 2001. There is a memorandum and all, but this is the subject agreement. In the event, you will find matter of disputes between Paradeep Phosphates and Paradeep Port Trust. In the event of any dispute or differences relating to the interpretation and application of provisions of the contract, such dispute differences shall be referred to either party to the arbitration of one arbitrator, Department of Public Enterprises to be nominated by the Secretary Government of India. Arbitration Act 1940 shall not be applicable to the arbitration under this clause. The award of the arbitrator shall be binding upon the parties dispute. However, the party aggrieved by such award may have a further reference for setting aside division of the award to the Law Secretary, Department of Legal Affairs. Upon such reference, the dispute shall be decided by the Law Secretary to the special so-and-so, when so authorized by the Law Secretary, whose decision shall bind the parties finally and conclusively. So this is again an internal thing. These are two. So the next point I should make is at this point of time again we are two public sector undertakings. Since I am on this, you may just note a date. 28 February 2002 is when there is a share purchase agreement between the President of India and the Zuari Group. If you have that SLP, it's the next, very next document on 102. It's just the next. So therefore, we didn't really look at it, but just to place it so that Your Lordship has cited it, because the question was put.
It was given by.
Sorry.
It was given by.
Yes, you need to, nothing. At this point of time, 74% was sold. Balance was retained, and then it was sold later. All right. So that's just for our information. Now we go to the arbitration award, which is very important. Now I go to the arbitral award, which has not yet been placed. So it's at 102 of the SLP 9751 of 2023. And my endeavor will be to persuade you that this is a very well considered award. Evidence has been considered, issues have been mutually framed, each aspect has been taken up, and there's a plausible view. If it's not the correct view, it's certainly a plausible view on every aspect taken. I mean, we may disagree with it. You can always say that, oh, it doesn't seem to be. I mean, I might have decided it differently. But it certainly doesn't meet a threshold of perversity, which I believe is the correct threshold if someone wants to overturn this award. So Your Lordship has the date, 27th December 2002, on page 102. And then presided over the arbitral tribunal, the sole arbitrator is Mr. N.C. Jain, Joint Secretary Legal, etc. Now please go, if Your Lordships would, to just the opening paragraph at page 104. Whereas these are the recitals. N.C. Jain, Joint Secretary Advisor, so presently posted as a sole arbitrator in the permanent machinery of arbitration, Department of Public Enterprises, was appointed as a sole arbitrator by the Secretary, Department, etc. to arbitrate upon the commercial dispute. I entered upon the reference on 31st August 2001, issued notice to both the parties, etc. Then with your permission, my lords, I am skipping the recitals and taking you directly to 110. Justice Sundaresh has it, my lords? You found it. So on 110, now the arbitrator is summarizing claimant's claims. So may I just set them out? For an early, towards the foot of that page. For an early refund of 10.33 crores collected by the respondent, which have been deposited by PPL under protest with PPT authorities towards the consolidated cargo related so-and-so, apart from interest at such and such rate. That's one. Then second claim is waive the interest of 53,11,000 claimed in contravention of the provisions of the agreement. The third is review the fixed berth charge of 30 lakhs per month. So I had asked for a review of the fixed lakh, because you remember I had said that this is higher than all these other states. So we asked for it, we didn't get it. And then please see, so that's what it says. Then arbitrator at the top of 111 says, Respondents in their counter statement of facts and counter claims explained their position. So with your permission, I'm skipping that. You have already seen that comparison, my lords. I've already seen that comparison, correct? Between the percentage increases and all that you have marked. So I take you straight away to page 115 now. 115. In light of the aforesaid, last or second last para on that page, in light of the aforesaid, respondents have said that the claims filed by the claimants are neither permissible under the law nor on merits and therefore need to be rejected. They have further filed their counterclaim for 53.11 lakhs on account of interest for the late payment and for fixed charges. Out of this sum, a sum of 14 lakhs 52,000 has already been recovered, and they have claimed 38.58 lakhs as the dues payable by the claimant. The request that the award for the said amount be made. So they counterclaim for that amount which was paid. Now see issues. After the aforesaid facts are analyzed and the submissions made by the parties, the following issues have been settled with the consent of both the parties. Consent of both the parties. What was the scope and ambit of the agreement entered into between the parties? Whether the tariff as provided in the contract can be revised unilaterally without the consent of the other party. Whether the rates revised were reasonable, my lords, it should be reasonable. And the respondents are given circumstances justifying enhancement of rates. Whether the interest claimed by the port authorities for delayed payment was permissible under the contract or under the statutory rules and regulations. Whether the claims and counterclaims filed by both the parties are tenable in law and merit. So I am only making, this is settled by both the parties. You will note that, there is one aspect which was canvas on limitation, though there's a discussion on it, so I'll take you to all that. But there's no issue on framed on limitation at that time. Because there were all these negotiations which were going on between the parties. Please, what do we do? Have a meeting, do this, do that. Anyway, that was. Now please see issue number 1. What was the scope and ambit of the agreement entered into between the parties? Now, I am skipping, you have seen the heading. Please go, if your lordships would, directly to page 121. I'm just reading the paragraph before the discussion first. So that's the second last paragraph. The respondents, on the other hand, have said that there is no dispute as to the contents of the execution of the agreement between the parties. Correct? As far as the scope and ambit of the said agreement is concerned, it was explained that clause 19 of the agreement provides that the agreement is subject to relevant rules, bylaws. This meant that if there is a change in the law in regard to anything, including the rates, etc., the same would be applicable in the case of this agreement also. Agreement 2, it was also explained that since this is the application of law, will have the precedence over the terms of the agreement, and the change shall be treated as deemed modification of the agreement. Now starts the discussion. So this next part becomes very important, and I believe this is a full and fair discussion. I have gone through the submissions made by both parties, the terms and conditions of the agreement entered into between them, and oral arguments made at the hearing. It seems that the terms of the agreement are very lucid and beyond doubt. The agreement covers not only the rights and obligations of both the parties, but also the charges which are payable by either of the parties. It is also explained that the rates can be modified subject to consent and assent of both the parties. The agreement did not have any duration for its existence and can be treated as perpetual. The respondents, of course, have raised the plea for the relevant rules, laws and bylaws, etc. of the port under the Port Trust Act. It is true that any regulation enacted under the Act will be the law and will be applicable between the parties. However, the rates fixed by the parties as a special case shall have to be taken into consideration and shall be respected by both the parties for the future interconnection. The provisions for payment of interest may be applicable as per the clause because nothing is provided in the agreement. But if the agreement contains a provision that will have to be complied with by both the parties according to the letter and spirit of the agreement. Therefore, clause 19 of the agreement shall be applicable only for other port charges and cannot provide any help to unilaterally change the terms of the agreement. So this is exactly the argument I articulated. Now, it may not be the only view which is possible, but he's seen it, he's seen the schedule. He says that, look, it's for port charges, you apply clause 19, but not for the others, because he finds the agreement very lucid and very clear. Now, let's see issue 2. Whether the tariff as provided in the contract can be revised unilaterally without the consent of the other party. That your lordship has seen. Now please go directly to page 124. Last para. It is wrong to say on the part of the respondents that the challenge to the enhancement of rates in the year 93 was an afterthought and no bearing on the claims of the claimants. Immediately after a proposal was received by them, they have promptly objected on 16th March 93, Exhibit 4E, on the ground that the Paradip Port Trust is not empowered to decide on the proposed revision in view of clause 01 of the bilateral agreement dated 3rd August 1985, and clearly stated that such proposal amounts to unilateral increase of the schedule of rates. Further, in 93, the scale of rates are being given a bilateral agreement was published from time to time and was made applicable to the port scale of rates published by Paradip Port Trust. The notification issued in 89 and 1991 may be perused as the illustration for enhancement of the rates and making sure that the rates can be enhanced only by mutual agreement. They have further referred, namely, now my lord, some of these I read, so I'm not going to read them all, but 2nd December, 8th January, so he looks at all this. Thereafter, a consolidated letter giving all the provision references was sent on 13th April 98 at page 33 of the statement of claim, but of no avail, and subsequent letter addressed to Dr. Devendra Pradhan, the then Honorable Minister of the State for Surface Transport, giving detailed note and the factual position was sent. It was only thereafter that the Managing Director wrote to the DO letter to the Chairman of the Respondents, this I referred to, on 4th November 1998, again providing the facts and how the rates in the year 93 need to be reviewed and not to be charged from them. The reply to this DO letter by the claimants of the respondents on 17th and 18th December 98 may be seen at page 3 of the statement of claim, explaining the dispute as to the revisions. Because the word should be averse, not average. The Port Trust is not averse to the ideas of revision of the agreement, particularly with regard to the number of their slabs, etc. However, the review has to be taken of all aspects so that it can be operative on the basis of mutual agreement. You may indicate your convenience for a preliminary discussion on the subject. The aforesaid observation by the chairman of the Port Trust clearly indicates that the revisions in the year 1993 were not final and they were not averse to discuss the revision on the basis of mutual agreement. Now, I think this is a possible view. It's certainly a possible view. It's a plausible view. Reading on. It is further explained by the claimant that they refer to the proposal of the respondents and the order of the Tariff Authority for major ports ordered. Sorry.
Just a minute.
Yes. Where was I? What do you want me to do? Still to go? Yeah, exactly. You're right.
Is whether, in the light of the fact that in the period 2000, 2005, 2007 and 2011.
No, we are asking about the present scenario.
Yes.
How the tariff authority fixes some tariff.
Today, my lord, 2025, yes.
25.
Yes.
What is it now? Is it open to them to go for that authority and then ask that authority to review it?
Yes.
I see.
Because my lord, not as review.
When it is notified, there is no power of review.
No, there is no power of review after a notification. But my lord, that there is subsequent, that it is notified from time to time, it's not in doubt.
Yeah.
So my lord, charges change, costs change.
That's correct.
Yeah.
Suppose if it is notified.
Yes.
Now, what is can they go before the such authority or they can only work out the remedy otherwise?
My lord, after that, my lord, if they have some grievance, then my lord, apart from filing a writ petition, my lord, I don't see any option. But my lord, at that time, what we have argued,
Factual aspects have to be gone into by a writ court then. Suppose there are some factual aspects.
my lord, may not be, my lord, then the remedy may be limited.
No, if the remedy, that's a judicial review kind of.
Yes. Parameters of judicial review may have to be maintained.
In the face of it, some error is found.
My lord, on the face of it, if an error is found, my lord, I suppose
Will correct.
my lord, a read court will send it back.
There is no apparent statutory mechanism there.
No, thereafter there is no
Is it way
statute.
for a review or by an appeal? Nothing.
No, periodically you can always make a tariff, my lord.
We are on the other side.
Not periodically. For example, let us say 2025 May. They fix it.
Yeah.
Either you or they have a grievance on this.
Yes, but it's not
Notified.
process.
No, so they have, for instance, my lord, 2013, they have challenged it in a writ petition.
We are
Oh, I see.
the notification.
Let's check with the new plan.
They have not challenged. Once we implement them,
We are not on the facts of any case.
Yes,
We are on the principle.
yes,
Suppose on 1st January 24, you notify the rates,
yes.
right? One party is aggrieved. That party goes to the writ court. In writ petition, one is judicial review. On the face of it, we see the procedure and all that, no factual aspect. Fine,
Yeah.
over. But the court finds that, yes, there are some glaring factual errors. The idea is whether the writ court will correct all these factual aspects.
No, my lord,
Your lot will send it back to the authority.
I have no doubt, my lord, that the writ court will send it back, perhaps saying, my lord, that there is a glaring factual error.
That is more like a remand.
Yes. Yeah. And, my lord, a glaring factual error may amount to a perversity.
But we take it that no party can approach the tariff authority again thereafter.
Yes.
No, not for that period. Not for the period that is.
not possible.
Yes.
Statutory
Statutory
you are saying, after launching you say,
Yes.
if this order is like continued and again they will go it. How is it?
No, the principles, my lord. Now, my lord, in this order, in the second order, my lord, the TAMP order, we have said this should be calculated in this fashion. They have,
Oh, I see.
They have
Therefore,
held
the
that it
methodology mode they will.
so the methodology has got determined, and the methodology will be applied, my lord, in other new tariff determination. They will say that this is the principle.
We can clarify, no problem. Okay, anyway, that's for a tariff authority to say.
Yeah, but
Nobody
they've
can
not-
say
you've done
they
it
follow this.
well.
Anyway, that's being followed by them only.
Yeah.
No,
You can follow ARB, as you rightly said, that's a possible or plausible methodology. It's for them to adopt.
my lord, if the no, my lord, what I am saying is, my lord, that if the methodology, my lord, is as it is today,
It's not like tax that every year is
Ah.
independent.
no, not every. Not every
Yeah,
year.
It is a change in circumstances.
For them to do it.
No, my lord, methodology, my lord, like for instance, I said, will a particular expense be booked under this head or that head? Once they have booked it under one head, my lord,
No, don't worry, that will clarify. I don't think even they will contest on that. But
Yeah.
nobody can say that. It is only for the purpose of determining the tariff, only they do it.
Yes.
The flexibility is for them. There's no law on that.
no,
Like Institute of Chartered Accountants, they continue to have their accounting standards.
yes,
They sometimes revise also with the passage of time, things may change also.
my lord, but my lord,
Parameters may change.
but my lord, this is a tribunal. A tribunal, my lord, your lordships have held many times that the tribunal is bound by its own principles, its own, my lord.
May change for fixation of tariff. May for that what is done
No,
previously.
we will clarify that, no problem.
All right. And only one thing I should tell your lordship, my lord, that my learned friend is pointing out, that there is a power of modification and cancellation of rates, but that is given only to the central government. Under section 54,
After this authority's order,
yes, yes. So therefore, my lord, in the Major Port Trust Act 1963,
but
this is the new act. In the new act, my lord, there is a section 54. Whenever the central government considers it necessary in the public interest, so to do.
That's the general power.
Yeah, that's a general power.
not routine.
General power. See, now we are only concerned with us. We are only worried that this could be a triggering point.
My lord, it
But we
will.
don't think so because 52 is also not there now.
No, the difficulty is this.
Now the tariff authority has come now.
Tariff authority is on its own.
It's an independent determination, my lord.
But, my lord, the principles they will follow, my lord. Your lordship knows, my lord, that the argument will be, my lord, that this methodology should not be departed from.
See, at apprehension we allow it, no problem. We will clarify the research. I don't think that's an issue there.
Because it can be year to year also, or whenever the tariff is revised. In electricity, it is annually basically.
No, that is, my lord, figures. That is figures.
Figure also. Maybe principles also change for
My
fixation.
lord, principles do not normally change unless there is some major change, my lord, in the overriding facts.
Yes.
Yes, I'm sorry. So, my lords, I was on page 125.
But here it has been 1 year.
Then we have given the medicine. So much we have increased. Then given the opportunity, we have passed the order. Now they go to the High Court. High Court is sent to the PPA.
No, that's all right.
Take his own order, but he's saying right.
No, we've said, no, writ court can do it.
I think he also shortcut it. It seems that he's exhausted with wasn't. Okay, I'm sorry. So, Manoj, I was on page 125. 125 of SLP 9751 of 23.
Yes.
Where, after making a reference to that correspondence after the italic portion, the aforesaid observation of the chairman of the Port Trust clearly indicates that the revisions of rates in the year 93 were not final and they are not averse to discuss the revision on the basis of mutual agreement. It's further explained by the claimant that they refer to a proposal of the respondent and order of the Tariff Authority for Major Ports dated 9th.
Correspondence here is reflected.
Yeah, he's referred to the. Now, just see this next part. Arbitral tribunal is looking at, listening to on their argument and what is happening around the scene because the Tariff Authority has come. Further explained by the claimants that they refer to the proposal of the respondents, that's the other side, and order of the Tariff Authority for Major Ports dated 5th December 98, published in the Gazette dated
For a change, the arbitrator acted like a judge. In the sense,
he's looked at everything is what I am saying.
I'm telling you.
Yeah.
Usually, arbitrator will go into the nitty-gritties and then find out this is a methodology, there's a methodology, this is to be done. Like he was pointing out with the tariff regulatory authority. Here, he only found fault with here and there and said nothing.
Who the arbitrator?
There are two things he could have done. Number one,
The arbitrator has done the job which he framed the issues, he's considered everything.
the objective of arbitration is that
Yeah.
he used to find out
Resolve
whether the
the dispute.
enhancement is right or wrong.
Sorry?
Or whether enhancement is right or wrong, number one.
Whether it's
Unilateral tariff.
it's there.
And the other thing is then he has to fix what is the actual pay amount that will be paid.
He's done that also.
Yes.
No, he has not done.
No, I'm showing you, he's rejected the claim.
But he says 93 revision is bad. That's all.
No, so what was the issue? The issue before us, I read those issues. The issues were that look, 93 revision, could it have been done unilaterally? That was one point.
That's
So
all.
he applies his mind to it.
Fine.
And he says that it can't be done unilaterally. That's one. The second is, whatever the consequences which I'm going to place before you, he gets into. And then he says, moving forward, the correct jurisdiction will be TAMP. And so we will then go into TAMP, and therefore for the period which I gave your lordships, from 1st April 99 till 2010, it is TAMP which has decided it in the thing. Arbitrator didn't say till 2010. Arbitrator said it only till...
But what about 93 to 99?
So 93... Sorry.
He has said
Yeah,
this is not correct. I'm setting aside.
correct.
But then he should have. He can't leave it in limbo.
No, he's gone into that. Don't worry. He's gone into that. He's looked into that because whether their increase, etc., was justified or not.
What was the reasonable increase then?
No, there's no question of reasonable. See,
It has
see.
to be.
No.
You see clause,
See.
clause 20.
Yeah.
You have read.
Yeah.
Arbitrator could be appointed if
Yes,
clause
yes,
is there.
yes.
So what is the duty of the arbitrator? To find out what is reasonable. You
No,
say
no. That is it. Is a claim. Let's go step by step. There is a claim and there's a counterclaim. I have placed those before you. My claims were that look, this increase from 93 is not justified. This particular interest is too high, and I should be entitled to a return of monies, etc.
Right.
What was his claim? His claim is that no, my increase is justified, and I should be entitled to recoup the unpaid interest which he got. These were the claims and the counterclaims. Now, having looked at that, pleas are raised, etc. So he has to first satisfy himself. What is the correspondence? How are parties looking at it? That's the part I'm on just now. So he's examined it in minute detail. Is my respectful submission. You will very seldom find an award which is so carefully drafted, examining the issues framed, agreed issues. The issues which were framed by the...
Basically, I agree with you on the reasoning of the arbitrator or finding of the arbitrator.
reasonable, possible view.
That they have acted unilaterally. That's one part. We need not elaborate much on that.
Okay, so I'll go on.
Please highlight to us
Yeah.
where has he applied his mind and say it's a case where there cannot be any increase. And then what is it? How the increase is done?
So we just come to that.
Which means, did he make any attempt to fix the?
He examined it, Manoj. He satisfied himself on the increase which they claim.
That is one thing, sir. What we are saying is this: you must take each and every head like the Tariff Authority did on the investigation. Like they called for the document. Then same thing arbitrator could have done it.
No,
he could have done it. That's the reason why it gone to the arbitrator. Otherwise, like a court, we can decide. That's what I am saying. If you say the process adopted by them by fixing the tariff without consulting you or without consulting with concurrence of you, it may not correct. Then the next question would be, what is the correct the thing? For that, he has to take the material. All right, what are the basis?
Yes.
Call for these documents are there. And
We'll see that.
Please take us to
Yeah, we'll take that.
Is there?
Yes. So now, Manoj, I was on page 126.
Yes.
If your lordship just goes.
Yes.
126. Just go to paragraph therefore. Therefore, they have submitted that any unilateral fixation of tariff and publication thereof are incapable of being imposed against the claimants in view of the clear stipulation in clause 1.
It can't be. All right.
Yes, it can't be. I'm grateful. Now then, respondents on the other hand. Now, then your lordship may just go.
Page 130 is that finding.
No, go to 120. You're right, but just go to 127.
Yes.
Because that has something to do this time. Just see this 127. The respondents have further said that Paradeep Phosphates had not exhausted all avenues available to redress the dispute by approaching the Honorable Court, a high power committee for settlement of disputes. One such avenue available as per clause 20 was to refer the disputes to arbitration. Port trust, which was not invoked by the claimants. Further, they have explained that it is not proper to say that
These are all the contentions. Come to 138, 128.
yeah, except there's a finding at the foot. Therefore, the allegation that the port is
These are all again.
collecting charges at a higher rate unilaterally at a modified 3 tiers is denied as incorrect.
It's their case. Yes.
Okay, correct. Now see the findings at 128. 128, is that where your lordship?
Yes, that's it. I
Yeah,
want to read.
okay, 128, I'll just read the findings. I have gone through the pleadings filed by the parties and the submissions made during the hearing. It is a fact that clause 1 of the agreement entered into between the parties in the year 1985 provides for a mechanism to change the tariff from time to time with the agreement. The respondent recognized this agreement, and the notification in the year 89 provides the terms of the tariff as special tariff applicable to Paradeep Phosphates. In the year 91, when the rates of some of the heads were revised, nothing was changed as far as the claimants was concerned. It is also a fact borne out from the records that the proposal to enhance the rates, a fact sent to the claimant, and the claimants objected to it on the ground that the rates are already higher and no revision of the case should be made. In spite of the fact that the claimants objected to the revision, the respondent suo moto enhanced the rates and obtained approval of the central government before notifying these rates. This no doubt is a unilateral decision of the respondents imposed on the complainant or the claimants, and a clear breach of agreement in absolute terms. The plea of respondents that acquiescence.
But it starts from 130. And then the issue number 3 is what we are.
All right, I'll get into that straight. So very well, I'll go to 130. But your lordships have seen 129, the finding.
That's correct. That's what they are saying that
Unilateral.
It is not correct.
Okay, then bottom of 129 he considers scam. Now I'll go to 130.
Yes.
Okay, now just see the last 5 lines on page 129.
Yes.
Because he's dealing with the Oswald case, etc. So just see last 4 lines. Since the respondents already were ready and willing to review the enhancement of rates in 93, I became a private and went to a. Now see this last 5 lines, very, very important. Last 5 lines on page 133. It is much surprising that the rates which are enhanced in the year 93 are justified by the port authorities in the year 98, and that too in the case of a private enterprise in comparison to a public undertaking. In case of Oswal, a new berth was constructed by investing money of the port authorities for a huge amount, etc.
consideration something.
So see the last part, he eventually says that a OC